Good morning, everyone. We're going to give people a few more minutes to jump into the webinar, so we'll get started here in just a few minutes. Okay, the number of individuals who are joining us seems to have evened out a little bit, so let's get started. My name's Tawny Alvarez, and I'm a partner in Verrill's Labor and Employment Group. And today I'm joined by my colleague at Maine Street Solutions, Peter Gore. Welcome to the 2025 Maine Employment Law Legislative Roundup webinar. Today, we're going to be discussing significant employment law developments from the 2025 Maine legislative session. In addition, because we want to make sure everyone is fully prepared for what the next 6 months, year, and general future will look like, we're going to break up the end of the presentation with some stuff that's going on federally as well, so that you understand interactions that those changes may have on these changes in Maine law more generally. During the course of this, we're going to be breaking down some of the key bills. We're going to highlight compliance considerations and answer questions about what the new legal landscapes mean for your organization. Throughout the course of the presentation, if you have questions, don't hesitate to use the question and answer feature in the webinar. A couple of quick notes before we do get started. For those of you who are unfamiliar with the webinar series, this will be recorded and emailed to you along with a copy of the slides in the coming days. The webinar has been approved for 1 SHRM credit, and CLE credits for attorneys on the webinar is pending. If you are an attorney, what will happen is we'll submit your name to the Maine bar for CLE credit once confirmed. We'll also send you a certificate for your records, as well as for those of you who need SHRM certification, you'll receive a SHRM certificate as well. Again, if you have questions during the presentation, please enter them into the Q&A box and we'll do our best to answer them in real time. Thank you, and let's begin. Jump to that first slide. So as we noted, Peter and I are really going to focus in on Maine state action and activity. And Peter and I have broken this out into 2 concepts. One, the laws that have passed and have either been enacted or waiting to see what the governor is going to do. And then the second category is those that were not enacted but are still alive that we'll see next legislative session. So things that people need to have on their radar more generally. Let's go to the next slide. So some general expectations. Peter and I think it's really important to set the stage as to what you can expect more generally as you operate in Maine before we get into some of the more specific areas that we saw laws being created in over the course of the last few months. One, we expect to see an increase in DOL investigations, both from the state and the federal level. As it relates to the state level, in 2024, most of you are aware that penalties were increased and there were updates to statutory damages available to be imposed on employers under DOL investigatory functions. So we do expect to continue to see an increase in general DOL investigations, both on their own behalf and as a result of complaints that they receive from your workforce. Second, a general increase in OSHA health and safety investigations. While primarily we're seeing those linked to injuries, sometimes those are even minor injuries, cuts on the hand or not a loss of limb or life, but increase in OSHA health and safety investigations with the understanding that the fines associated with those, if you are not in compliance, are not $500 or $1,000 anymore. They're $6,000 plus. So they definitely increase kind of what's in play more generally for Maine employers. And then finally, an increase in Maine Human Rights Commission and EEOC filings. In a lot of situations, historically, we find that's tied to market, more layoffs and more terminations at the end of 2024 in our experiences, also in the beginning of 2025. And that is resulting in more charges being filed with the commission. The commission is extremely behind, based off of the sheer quantity of filings that they're seeing, both related to alleged housing discrimination, which takes priority over employment discrimination matters, and then just in general, based off of where we find ourselves from an economic reality standpoint. So those aren't specifically related to the legislative session, but they're things that are important for all of you to be aware of as we go into the next few slides. So Justin, let's jump into that first act. So the first act we want to talk about, it was passed. It's called an act to amend the law governing accrual of earned paid leave. And this is a good time for me to introduce Peter and for Peter to give everyone a little bit of background on the work that he does. You all know I'm a labor and employment attorney. I help you all figure out how to comply with the law. Peter comes at all of this information from a different perspective, and I'm going to let him share that now.
Thanks, Tony, and good morning, everyone. Thanks for being here. It says government relations consultant, but I'm really a lobbyist in the State House. I've been doing this job for Maine Street Solutions for the past 3 years, and prior to that, I was 29 years with the Maine State Chamber of Commerce, and I specialized in the area of labor, the workplace, workers' comp, and health insurance from a policy perspective. So, on behalf of my clients, and I'm not an attorney, I watch a variety of different laws that impact how they do business, how they manage their business, and how they manage their employees. And so we're going to talk about some of that this morning. It was an interesting legislative session, not so much because of what they did, but what they didn't do and what remains. So we'll talk about some of that. But with that, Tony, why don't we jump into 55?
So 55 amended the law governing accrual of earned paid leave. You'll all recall that in 2021, the earned paid leave statute went into effect, providing that all employers needed to provide employees, no matter what type of employees they were, per diem, part-time, full-time, temporary, up to 40 hours of paid leave that could be taken for any reason. So unlike a lot of states that have more of a paid sick leave bucket for employees, this employees were able to take the leave for whatever reason they choose, whether it was for vacation, for doctor's appointment, for car issues, any reason that they foresaw with certain limitations. The LD 55 amends it. It has already been approved by the governor, so this is going into effect. And what it does is it provides that if an employee fails to use accrued or unpaid leave in the year in which it was earned, they are allowed to roll it over, and that rollover doesn't adversely affect their ability to earn additional time in that next year. Now, those of you who followed earned paid leave closely and had to craft policies around it will recall that previously the statute provided that if an employee decides to roll over from year 1 to year 2, 10 hours of earned paid leave, they would only earn 30 hours in year 2. That is different now. Now the employee will accrue up to 40 hours in that second year. So they could have up to 80 hours to use in a period. Now it only rolls 1 year to the next. So if somebody has earned paid leave in 2025, that they don't use and they roll it into 2026, they would have to use it in 2026 because the 2025 time will not roll all the way to 2027. It would expire in 2026. However, the time earned in 2026 could roll over to 2027. So you could have employees with up to 80 hours of leave that is available to them in the course of the year. Recall that the earned paid leave statute, the determination of the pay rate is different from just the base rate of pay. It takes into account bonus in determining what the regular rate of pay is. So for those employers who do oftentimes have non-discretionary bonuses that are playing role in what the regular rate of pay is. You likely have experienced times where employees are taking advantage of that in determining how they're paid in the use of earned paid leave. This will provide for an additional, up to 40 hours, because 80 hours in a year if they roll over because they hadn't taken time the year before, more generally. So it doesn't increase the amount of time. They still only get 40 hours in a year, but it allows them to hold on to it without loss of time more generally. Our recommendation here is that employers update their policies sooner rather than later to make sure that it is clear and sets forth kind of exactly what LD 55 sets forth here. Peter, any of the background that you can share with people concerning this? I feel like this went a little bit under the radar as it relates to things that lobbyists are focusing on kind of over the course of the year.
Yeah, there was a lot of confusion around this bill. As I remember, this is Dick Bradstreet's bill. So he's the Republican senator, and he put the bill in at the request of a couple of employers in his district who asked for the ability to have the rollover. And there was some discussion about about the discrepancy between what the rules said and what the statute said with regard to the ability to allow an employee to roll over excess time, but still have a cap at a certain amount. I think the feeling was that the statute didn't allow it, but the rules seemed to imply that you could. So the purpose of the law change was to clarify that an employer could allow the rollover. But Tony, I will say, I thought it was discretionary, and maybe I'm wrong, that you only allowed the rollover if you had such a policy in your existing handbook versus just automatically allowing the rollover. But honestly, I got disjointed from this bill as time went on with other bills, so I didn't follow it as closely towards the end. And it was one of the last bills. And because it was a Republican bill and because it dealt with earned paid leave, there was a lot of suspicion on the part of the Democrats on the committee about what exactly Senator Bradstreet's goal was. But it was really pretty simple to allow people to roll over, employees to roll over time.
So previously under this statute, you could allow them to, but you weren't required to. And you didn't have to allow any rollover if you used a method that was non-accrual based. So if on January 1st, you simply gave all employees 40 hours of earned paid leave, there was no requirement that there be any rollover at all. However, if it was an accrual method, then you had to allow that time to move forward with the understanding that under the statute, it previously said you don't have to allow an employee to ever use more than 40 hours in a calendar year. So the use versus accrue is the big difference here. This would now allow both the use and accrual of the 80 hours kind of in the year. We did get a question as to, do you have to pay out the 80 hours when they leave? Um, it's going to depend on your handbook, right? So there's no requirement that you pay out earned paid leave at the time of termination of employment, unless you're putting earned paid leave into your vacation bucket. If you're calling it vacation, then you have to pay it out at the time of termination or the time employment ends. If your bucket, however, still calls it earned paid leave, you can treat it that it's not paid out. You could, and some people do have a policy that says we'll pay up to 40 hours at the time of termination. As long as it's not called vacation, you can choose how you treat it. If you call it vacation, however, you have to pay it out at the time in which separation from employment occurs. So good question. Let's jump to that next slide. Okay, another past bill, the Employee Surveillance Bill, LD 61. And Peter is going to go into some detail about kind of what this means. And this is the one bill that before we jumped online, Peter and I went back and forth on double checking the news, making sure we didn't miss anything right before we got online with all of you. So what the bill says is employer surveillance cannot be used unless the employer notifies the employees beforehand. So making sure that you have language in your employee handbook that says surveillance could be used. There is exceptions though on what employer surveillance is, right? So employer surveillance is considered the monitoring of employees through electronic devices or systems. That could be computer, so keystroke monitoring, telephone for any of you in the finance industry who may record client service, phone calls, radio, photo optical, unless it's for security or safety purposes or global positioning systems. So there's three exceptions as to what employer surveillance is not. It's not surveillance that's used for security, it's not surveillance that's used for safety, and it's not surveillance that's used for global positioning systems. Of course, just to make my job super easy and to make all of your jobs super easy, Tawny, Peter, is security, safety purposes, or global positioning systems defined? Of course not, right? That would make it much too easy. Um, there is also no audiovisual monitoring in residences or in a personal vehicle. So if you have employees who drive their own personal vehicle for work purposes, there could be no surveillance in that personal vehicle. And also no audiovisual monitoring if you have employees working from home. You could still do keystroke monitoring as long as you're giving notice beforehand, or if it's for safety or security, you arguably don't have to give notice. There are some exceptions for personal care services that got in right before the vote occurred. So if you provide personal care services, I highly recommend you take a look at LD 61, which provides some additional exceptions. If you are using surveillance, you have to provide notice during interviews and then annually every year. Um, right before the bill was passed, there was a private right of action that included attorney's fees, civil penalties, and injunctive relief, but that language was removed. I'm going to turn it over to Peter to give a little bit of background on this, and then I'll turn it over as to some of the next steps employers should be considering.
So this bill originally was submitted during the last legislative session in the 131st, and it did not go anywhere because of the fiscal note. There is the Department of Labor indicated they needed money in order to enforce it. And also, nearly or 2 years ago, the the impact of the pandemic and employees bringing workers back to work, or the conflict around workers wanting to not go back to the office but continue to work from home versus the pull from employers saying, no, I need you back in the office. That's where this bill actually resulted from. And in reality, the sponsor of the bill was the only person who spoke in favor of it, yet the committee voted the bill out, ought to pass, divided. Republicans opposed it, Democrats supported it. Um, it's a it's a bill that has caused a fair amount of consternation in the business community, perhaps not for the reasons you think. As Tony indicated, because safety and security are not defined, there is some concern, particularly around employers, for instance, Bath Iron Works, who, for a variety of reasons, has to do monitored security in a variety of different ways. I have also heard from a workers' comp insurer and some self-insureds who say we use surveillance when we suspect fraud, with a workers' comp claim. Will we be able to continue to use it? And those kind of things. The bill landed on the governor's desk. It did have the fiscal note, what we call the fiscal note or the price tag, stripped off of it, and it basically said the department had to do it within existing resources. Um, in addition, as Tony indicated, the private right of action was removed. I don't want to get bogged down in the minutia of what happens when the legislature adjourns, but the legislature did adjourn on the 25th. And when the governor receives a bill, and she did receive it on the 25th, she has 10 days to decide what's going to happen to that bill once it's in her possession. And you don't count Saturdays or holidays. So actually, tomorrow is the final day that the governor has to act on this bill. And a number of folks in the business community have contacted the governor's office and urged her to veto the bill. My indication, and I know there's some other folks on this presentation this morning who worked on this bill, is she's inclined to let it go without her signature, but that's getting a lot of pushback. So again, I don't want to get bogged down, but so you understand, when the legislature adjourns sine die or without day, it means they're not coming back. Bills that are in the governor's possession, ordinarily, they would have a veto day, so they wouldn't adjourn sine die. So the governor could veto bills and the legislature could come back and vote on those vetoes. But they opted not to do a veto day. They adjourned without day. They have no plans to come back. When that happens, at the governor in the 10-day process, the governor really only has two choices. She can sign the bill or she can just shelve the bill. And when the legislature comes back, or if they meet for 3 days, then she would need to take action. And if she takes no action, it becomes law without her signature. So that's where we are in LD 61. If she doesn't veto the bill if she doesn't sign the bill today, then the real options are essentially a pocket veto until they come back in January, where she could allow it to become law without her signature, or she would have to veto the bill. We're all going to have to wait and see.
So presuming that this goes into law, some things that individual employers in Maine need to consider. One, the notice requirement, right? Notifying employees. So updates to handbooks and policies would be step one. Two, notice must be given during the interview and annually thereafter. Whether or not including the language in your handbook and having a handbook receipt each year is sufficient, I think likely. But I think another good way to do it would be to line it up with your sexual harassment policy. Um, Notification and verification so that people are being informed of their rights as it relates to freedom from sexual harassment, and then also set forth their expectations as it relates to surveillance. Additionally, making sure that someone on your HR team during the course of that interview process is notifying employees or applicants about the surveillance that will be used during the course of the working relationship is important. And then finally, the question becomes what is security or safety purposes? Global positioning systems, I think, depending on the technology used, is going to be a little easier to define, but the safety and security becomes more difficult. Is if you're a large retailer and you've got cameras to guard against shoplifting, is it security and safety kind of the premises more generally? Is it safety and security of employees? Kind of what is included with that definition? So some of that is wait and see. Other ones, I definitely recommend that you talk to counsel to determine whether or not you should still be providing notice to employees. With that, Peter, anything else on this one or jump to the next?
The only other thing I would add, and to your point, if you are a fast food service and you have cameras that monitor your line, for example, or monitor the front desk where you're accepting orders for the safety of your employees, is that monitoring for security and safety, or is that monitoring for what employers are doing and not doing? And that's going to be the kind of challenge I think that and the problem with the ambiguity with this particular piece of legislation.
Perfect. Let's jump to that next bill. Okay, LD 82. This one's a mouthful, but the good news is we don't have a ton to say about it because it maintains the status quo. So LD 82 was passed on June 25th. It's an act to amend the workers' compensation laws by extending indefinitely the presumption applying to law enforcement officers, corrections officers, emergency 911 dispatchers, firefighters, and emergency medical service persons diagnosed with PTSD. So there is a presumption in workers' compensation that if an employee who works in one of these fields experiences PTSD, that PTSD arose in the course of employment. That presumption was set to expire on October 1st of this year. This bill, however, repeals the expiration date and continues the rebuttable presumption indefinitely, meaning that if an employee experiences PTSD and they're working in one of these industries, it is presumed that the work in which they do is what caused the injury itself. That is rebuttable by the employer to show evidence that no, in fact, something outside of work is what is causing or had caused that PTSD. Peter, anything to add to this one?
No, it primarily impacts municipalities and some workers' comp insurers. It was a unanimous bill out of the Labor Committee, so there was no, and it was also a mandate, so it passed with 2/3. It's an emergency bill.
And I don't think there was much that we saw unanimous out of the Labor Committee this time around, was there,
Nope,
Peter?
was
Let's go to the next law. So this is pay to report to work, LD 598. So something that's really important, specifically for any of our guests who are listening today who work in hospitality, who work in seasonal positions, retail, hospitality, food services, all ones that this should be really high on their radar as to things to keep in mind. It applies to any employer who employs at least 10 employees. And what it provides is that if an employer reports to work and the employer cancels or reduces hours, the employee must be paid either 2 hours of pay or the total pay for the shift scheduled, whichever is a smaller amount. There are exceptions though, and the exceptions are if there's adverse weather conditions, civil emergency, employee illness, medical condition, or injury. So thankfully, what we won't see is an employee comes to work and 2 hours later has a migraine and then says, oh, I have to leave. And then we're required to pay. There is certainly some changes in this law between last legislative session and this legislative session that were positive for employers. For those of you who joined Peter and I last session or the session before, you may recall that this bill kind of, when it was initially um, put before the legislature included language which would have allowed employees to switch shifts and be entitled to this pay. So thankfully that language isn't here. The adverse weather conditions, I think, becomes a really interesting element. What does that mean? If it's sunny and you have an indoor, you know, uh, facility or something that doesn't do as well, maybe bowling, and it's a gorgeous beautiful sunny day, does the weather then adversely affect kind of business operations, or is it only adverse weather conditions that are directly affecting the employees as opposed to the rate in which you're seeing customers, clients, patrons kind of entering the door? That is less clear. But keep in mind, kind of both from a scheduling perspective as well as a pay perspective, something that you want to make sure your payroll team understands. Peter, I know I've talked a little bit about some background here, but other thoughts kind of more generally as to how we got here.
I mean, this is the restrictive scheduling bill that, or a version of it, that has been around for a few years now. My understanding is this is actually law in New Hampshire, where most of the problems that have arisen have been the result of improper record keeping by the employer around, notification. So, and the business community has somewhat mixed feelings on this. I think the retail and the hospitality industry are very disappointed, and she did let this bill become law without her signature. She didn't sign it. Um, I think that their belief was it was unnecessary and it adds, some element of cost. Other people have looked at this and said, well, the weather exemption is pretty broad, so that may make a difference. The notice section for employers will be a requirement will be very important because if the employer makes a good faith effort to notify the employee, you don't have to pay the wages. Here's what is likely to happen though, because the next sentence is if the employee reports to work after the employer's attempt to notify the employee has been unsuccessful, or if the employer is prevented from making notification for any reason, then the employee shows up for work and gets whatever duties assigned the employer wants to give that person. I think you could have a situation where you could notify somebody, tell them, look, we don't need you today, don't come in, and they show up anyway. And then you may be in a position of having to decide, are you going to risk not paying this person or are you just going to assign them duties for 2 hours and then pay them? I will say there is one other facet to this. Again, the Department of Labor came in and said, we don't have the resources to enforce this. So here's a price tag that it's going to take for us to do that. And the Labor Committee stripped the price tag off the bill. So essentially, the department, while they are required to enforce this, they have no methodology in which to actually do it. So whether there will be whether there will be an attempt to do it on their part or whatever, it's not clear, or whether they're just going to just throw up their hands to it. As I've said to a couple of people, what I worry most is for a few years, nothing really happens. And then a plaintiff firm gathers enough employees together to bring a class action suit against a large employer with deep pockets who says, these people haven't been paid their 2 hours. It's not like there's not precedent for that in this state. But again, I think for those of you who are concerned about this or impacted by this, notice to the employees would be very important, and then look at your adverse weather conditions.
Yeah, and one of the questions, does it make a difference if you ask for someone to volunteer to leave versus telling someone that they have to leave? I think under the statute, no. If someone asks to leave, not that it's voluntary, like who would like to leave. Usually the Department of Labor looks at those questions broadly asked by an employer as not a request because of the difference in power dynamics between the two different groups. If someone says, may I leave? Documenting that is going to be really, really important, showing it's 100% their choice. We didn't ask them, but that they made the choice kind of on their own completely, because it does know if the person reports to work, right? It's the reporting to work that's important here. So really great answer. And, I think Peter makes a number of really good points as to how we move forward here, more generally as it relates to 598. Let's jump to the next slide. Okay, what everyone's been waiting for, the paid family medical leave amendment. This is law. It was signed on June 12th. There are technical amendments that aren't super helpful to employers. Surprise, surprise. All the things that Peter and his team and a lot of the other lobbyists for businesses in Maine had been working to accomplish, unfortunately fell through, and he's going to give some background there. What it does is it clarifies that intermittent leave is in one workday unless an employer and an employee agree to a lesser increment. And then it provides the department with the ability to collect delinquent premium contributions. And then for all of the legal geeks who may be listening, there's successor liability for delinquent contributions. So if you often are involved in mergers and acquisitions, please make sure that this is on your counsel's radar as it relates to liabilities that could be forthcoming if there is successor liability. The real interesting stuff here, though, is going to come from Peter. So I'm going to turn it over to Peter to explain kind of how we got here.
I don't have enough time in the day to describe how we got here, unfortunately. Um, the As you all know, the paid family medical leave law passed in 2023. There was rulemaking that went into 2024. You were required to pay the first quarter's premium for if you have more than 15 employees for your company, and for you, and then you can collect the workers 0.5%. If you are under 15 employees, then you just required to collect the employees 0.5%. In either case, as an employer, you could choose to pay the full 1% or the 0.5%. Most employers decided to split that, and they paid their half, and the employees paid theirs. And I think the assumption always was, as you know, that the premium would be returned once you were certified to having purchased or intending to purchase a private plan. The state said, no, we're not actually going to refund your money. We're going to keep that money. We need it for seed money. That's contrary to what the legislature said in 2023. That resulted in litigation, as you may know, between Bath Iron Works and the Maine State Chamber and some others against the state of Maine. I believe arguments will be later this month, pending the outcome of that. It will be important if you're certainly administering the program, because you could lose a fair amount of your money if businesses prevail on this. But the other side of that coin was that the business community, and I see Nate Cloutier is on here with Hospitality Maine, and I want to give Nate a shout out for all his hard work on this. If any of you are involved in the hospitality industry, you definitely owe Nate a cold iced tea, because he really worked hard for you all. But there were a number of different provisions that were put together that were designed to change the program, but only to make the program more operational for the business community. There were operational changes. They weren't benefit changes. They weren't changes to eligibility. They weren't changes to length of leave or any of those things. There were two bills. They totaled probably 20 different provisions. I'm not going to go through each one of them, because at the end of the day, none of them passed. It was very unfortunate. The argument from supporters of the bill was that we need to give the program time to work before we consider changes. To me, that's lunacy. I've been around here long enough. You will never go back and make changes to a program that provides benefits to people if you're going to alter. They believe they're going to be altering benefits in any way. Needless to say, there are a lot of operational problems with the law. The return to work, the 90-day retroactivity is one. The lack of attachment to the workplace is a second one. We attempted a 120-day eligibility threshold, which is consistent with earned paid leave. That was a no. We wanted to clarify undue hardship. We wanted to clarify employee contributions. We wanted to change the Department of Labor's penalty structure, which is currently in rules, which is extremely punitive against employers who make errors in their calculations on the submission of the premium, even if it's not willful or accidental. It's purely accidental, excuse me. And yet the penalties for someone who defrauds the program are you just disqualified for a year. You don't even have to pay it back. Despite all that, didn't happen. I don't want to spend any more time on that. I think that for the supporters of the bill, they believe that, oh, well, we've weathered the storm. We knew it was going to be bad this session. Now we'll be fine going forward. That the problem that I and others have said to the supporters of the paid family medical leave program is that will never until there are real operational changes to the system. We're going to be doing this every single session. It might not be next year because you have to have permission from legislative council to get any new bill title in, but certainly in 2027 we will have a full plate of proposed changes to paid family medical leave again, and perhaps we'll be more successful.
Okay, Peter. So that actually wraps up what was passed. Let's go to the next slide and talk about what is on our radar for our next term. So, the next couple of bills, there's actually 5 total, 4 slides, 5 bills we're going to talk about. They all passed, but they died on the appropriations table, so they weren't funded. So they're each carried over to the next session, and Peter can provide some more details kind of on what that looks like. But the first one is LD 54, pay range disclosure. It applies to employers with 10 or more employees, and what it would require is a statement in postings as to the prospective range of pay to be offered to a successful applicant. Range of pay is very broad. It means the applicable pay scale, previously determined range of pay for the position, the actual range of wages, or a budgeted amount for the position. If it's a commissioned position, it wouldn't include compensation that commission element. Additionally, while it needs to be included in job advertisements, if you were not advertising for a position, but someone held the position, the employee is entitled to learn the pay range for the position that they hold. Additionally, there is a requirement that employees hold on to records regarding pay ranges for at least 3 years. Peter, more to add kind of to this.
Well, much like the surveillance bill, this bill, and the next bill we're going to talk about regarding flexible work schedules, these were all proposed in the 131st, so in 2023. Um, and as currently they're in the same position they were at the end of that legislative session, which is they're on the appropriations table because there was a fiscal note attached to it. And the Department of Labor is saying we can't do this without additional positions and resources. And these are bills that I call pandemic hangover bills. They're proposals that came about because people felt like the legislature needed to act to put in protections for workers around pay range. Disclosure of pay ranges in Maine has been a hot button topic. We have a specific piece of language in Maine employment law which says that it is a state priority to provide equality in pay, which is something certainly I support, and information around pay ranges between particularly women and men. This is an extension of that. In terms of the postings, you have to post not only in writing but online these pay ranges. This is again like the reporting to work pay requirement. This has been passed in at least New York, I know, and the pay ranges that some employers posted were from $1 to $1 million. And so that's just how they reacted to it. It's a lot of work for a small business. I'm not sure it provides the employee any real helpful information going forward, but I could be wrong. The employer community pretty much opposed this. Again, like LD 61, there was only one supporter of this outside of the sponsor. So it wasn't like employees lined up and said, we need to have this information when applying for work. The governor wasn't a fan of this bill 2 years ago. I'm not sure she remains a fan of it now. But the fiscal note is large enough on this bill that the legislature can't simply apply a little fiscal note, be gone, and pass it. So we'll see what happens. It's on the appropriations table. It was carried over to 2026, and we'll see if there's any money to fund it in the next year.
If you are currently operating if you have remote workers or operations in other states that already have pay disclosure, you've probably taken the steps you need to already to understand kind of implications here. If this is going to be the first state in which you operate in which pay range disclosures will be necessary, and whether or not this goes through the next session, or we're likely to see it, I think, in 2027 either way. Doing a wage audit is really important, kind of foundationally here, to make sure that people are paid appropriately. It also protects you against a future Equal Pay Act claim. So keeping that in mind is really important.
Yeah,
Let's
and the
go.
last thing I'd
Oh,
say is the opposition from the business community wasn't about, disclosing ranges of pay to prospective applicants. And a lot of times that's being done now, or it's being done in the ads anyway. So it wasn't that. It's the additional administrative burden that employers have as a result of this that is really the issue for what is widely viewed as a minimal impact. And the record maintenance for 3 years. I mean, it starts with employers with more than 10 employees, but that's still a small business. And requiring them to maintain records for 3 years is burdensome, whether people believe it or not.
let's jump to flexible work schedules. So LD 60, say it finds itself in the same procedural posture as the last bill, so it died on appropriations, will be carried over. This bill, however, is applicable to all employers within the state. In this situation, if an employee submits a request in writing, and that writing could be a text message, a letter, or an email, for a flexible work schedule, the employer shall, that's a must, right? Consider it, and then inform the employee in writing of the decision regarding their request for a flexible work week. And if it's accepted, then they have to mutually agree on how long it'll be in effect for. And an employer can rescind kind of that flexible work schedule, but cannot retaliate as a result of requesting it. You do not have to grant it. If granting it would be inconsistent with operations, and inconsistent with operations has kind of a number of different elements to it: detrimental effect on employee morale, adverse effect on customer demand, impact on safety, business quality or performance. One of the big problems that we're going to experience here, if this does ultimately become the law, is if you have a line employee who texts a line supervisor and says, hey, I'm having trouble with child care, can I be 15 minutes late for the rest of the week? That in and of itself is a request for a flexible schedule. Now, it doesn't matter that they work on a manufacturing line, right? And no, you can't be 15 minutes late because the line runs when the line runs. You would have to respond in writing, and you'd have to explain how it's inconsistent with operations and be able to evidence kind of that. So one of my big concerns here is that we're going to have employees who text or send an email that's kind of a one-off, and that our line supervisors are not going to recognize that they then have to bring this to HR. HR is going to have to do the analysis in order to respond, because it will be a flexible work schedule result. A civil action is available under the current language that was in the proposed law. There's also a civil penalty. And for anyone who's operating in a unionized workforce, this applies to unionized workforce as well. So kind of a double whammy from that perspective. Peter, elements to add?
I mean, as I indicated or said twice before, this is a direct result of, again, was first introduced in the 131st, so 2 years ago, as we were coming out of the pandemic and people being required to go back to the workplace versus working from home, et cetera, et cetera. I share a lot of Tawny's concerns with regard to notification. I have additional concerns around retaliate. That's a broad that's a broad world. And if someone asks for a flexible work schedule, and the employer says no, and later on there's an issue that arises which calls for an adverse workplace action on the part of the employer with that specific employee, that employee will be incented to say, well, this is really retaliation for my request for a flexible work schedule. So I do have some concerns with that. Business community was strongly opposed to this. Basically, what they said was, we don't need a law to tell us to do this. We are already working with our employees and providing flexible work schedules. We don't have the luxury of not being flexible in today's workforce, but we don't need the state to tell us what to do, and we don't need the state to put us in a position where we could be fined or someone could later on make a retaliatory claim. The bill has a fiscal note of about $100,000. It went to the appropriations table. It's still there. When they adjourned on the 25th, they just moved to carry it over to next session to see if they can come up with the money.
Let's jump to the next bill, 599. This again died on appropriations, carried over. This attempts to raise the overtime salary threshold to what would likely be 58,656, with the understanding that that would increase year over year. This again, will be carried over. We saw this last session as well. Where we see a wrinkle here is people may be aware that last week the United States Supreme Court issued a decision indicating that single judges cannot order injunctions that are applicable to the whole country anymore. Right now, under the Biden administration, we saw an increase in the salary exempt threshold under federal law. However, that increase was enjoined, and it remains enjoined at this time. It becomes unclear whether like the effect that that'll have as we move forward. So whether or not we see the salary increase from a state level or from a federal level is yet to be seen. But Peter, my understanding, one of the reasons this one died on appropriations was because of how much it was going to cost the state to increase their own employees' salary to this level.
That is correct. The fiscal note in the outer years is $15 million, which is, they don't have $15 million to spend on this. So that's certainly a bar, and it would be very difficult for them to apply this, not unprecedented, to apply this to the private sector and exempt the state. They certainly did on their report to work requirements, by the way. That does not apply to state employees. But in this situation, I think that they certainly can't avoid it, and then they can't do it without coming up with a lot of money. And the other thing too is Maine's salary threshold goes up every year with the minimum wage increases. We have an indexed minimum wage, so we're at almost 44,000 now, and by the end of this year, we'll most certainly be above that. So we're not like the rest of the country that remains at roughly what, 30? Is it 35,000? Roughly, Tawny,
Yeah,
uh,
yeah.
in that neighborhood. So we are, one could make the argument from a policy perspective. Maine is already addressing this issue, and they're doing it in a fair, more realistic way than just saying, well, we're going to jump to basically $59,000 a year.
Peter, this would be a good time too. I said to everyone that we had 5 bills to talk about, but only 4 slides. Can you give people an update on LD 998, the proposed amendments to the Bring Your Gun to Work Act?
Yeah. So some of you may remember back around 2013, the legislature passed a law over the objections of the business community that said an individual could bring a handgun to the workplace and leave it locked in their car in the employer's parking lot, regardless of whether the employer had a no weapons policy that extended to the entire workplace, the parking lot, etc. And as long as that individual had a concealed weapons permit. Maine went on 2 years later to pass constitutional carry, and there was discussion about this law and eliminating the concealed weapons permit requirement. They opted not to do that. The This bill 998 would have eliminated the concealed weapons permit requirement and essentially allow anybody to bring a handgun to the employer's workplace within the curtilage of whatever that workplace is over their objections and whether they have a no weapons policy or not. I was asked, I'm probably the only one in the building that remembers this. I was asked to testify on behalf of the Manufacturers Association. It was in judiciary, and they did, you know, I did get bipartisan support to leave the requirement for concealed weapons permit in place. I do expect that this will be an issue in future legislatures. It is concerning, you know, the concealed weapons permit isn't a lot, but at least there's some training and experience with a handgun rather than just allowing anybody who went to the store to bring it to work. There are issues with workplace safety. There are workers' compensation issues, and there's private property issues all rolled up into this. But guns and the ownership of guns is a big deal in the state of Maine, and at least for now, the legislature said no.
Thank you, Peter. Let's jump to the last bill that died on appropriation, so 799. So this will be carried over. Saved the absolute kind of scariest in my mind to the end. This is, the title itself, Report on the Gender Wage Gap, seems to be this is an Equal Pay Act type claim. What it does is it applies to anyone who employs at least one employee in Maine and 250 employees in the United States. And what it says is that the employer shall identify a week in which it collects data of gender based off of self-identification. So male, female, non-binary. And then what they'll do is they'll submit the median hourly equivalent rate of pay and gender for each of those. So the equivalent rate of pay for males, for females, and for non-binary individuals. There is no request for title, experience, position information at all, and this information shall be publicly available. It'll be published annually identifying the employer and the related data. And if you fail to provide the data, there'll be a $1,000 penalty for violation. Accordingly, this statute takes into account no elements of positions, experience, anything along those lines. Instead, it'll take all of your employees, put it in one bucket, come up with what the median hourly equivalent is, and it'll be male, that number, female, that number, non-binary individual, that number. So, 6 pieces of data, and that's all that's reported. It's problematic because it doesn't accomplish anything because it doesn't take into account any of that background information. Um, if, one of the questions we just got is if you have fewer than 250 employees, does this statute apply to you? No. If you have fewer than 250, it does not apply. But if you have one person living in Maine and 250, elsewhere across the country or world, this will be applicable. It creates some really big kind of larger legal questions. Peter, kind of thoughts or statements?
I mean, I agree with everything you said. There's no purpose for the collection of the data, and they're publicizing it. It's almost the purpose is almost let's create a wall of shame here in some factor, which serves no real purpose, and it doesn't. And it's just a number. It doesn't take into account experience, years of service, et cetera, et cetera, et cetera. Everything that Tawny said. This was very aggressively opposed by the business community and had very few supporters, particularly because it just doesn't do anything. It's a lot of work for the department, and they put a $200,000 fiscal note on it. I don't think this bill is going anywhere this session, but that doesn't mean it won't be back in in 2 years.
And then, Peter, we got a question concerning the guns at work, the 998. How would that affect schools or daycares? I think it applies wholeheartedly without regard to industry, but can you confirm that?
I think there's a separate statute that deals with schools and the ability to have a weapon at school, so I'm not sure it affects it. As far as daycare goes, I don't think that same exemption exists. I think it's municipal property, schools. There's one other courts, but that's I think it. And I'm doing that from memory, so.
Thanks, Peter. So, at the outset, I talked about how we are really going to focus in on Maine legislature, but talk a little bit about overarching federal things that are happening. In the slides that you'll receive, you will receive information about that, but just really quick, without going through the slides. If you've been following executive orders, you will see that there is a new push by the federal government to get rid of disparate impact analysis, which is that you have on its face a valid statute or rule that doesn't discriminate on the basis of gender or race, but that the way it interacts with people does. It's going to be interesting to see how this interplays with artificial intelligence cases more generally. Federal non-compete, right now, we know that the regulations that Biden had attempted to enforce are currently stayed and have been enjoined. Right now, actually today, we will have further information as to whether or not the Trump administration decides to move forward and continue to appeal that finding, or whether or not it lets that go and allows the FTC rules to die. We're going to see further emphasis on DEI and diversity initiatives, with the EEOC really looking at employers who are focusing in on diversity, equity, and inclusion. 2 weeks ago or last month, the Supreme Court came out with a decision, Ames v. Ohio Department of Youth Services, saying there's no such thing as reverse discrimination. The standard for someone who finds themselves in a majority class is the same as for someone who finds themselves in a minority class. This isn't really news for Maine employers, however, because the First Circuit and Maine law already had the same standard in place, whether or not you found yourself in a majority class or a minority class. And then finally, what do we expect to see from the EEOC? We likely will see regulations concerning the Pregnant Workers Fairness Act either repealed or downplayed, more attention on disability and religious discrimination claims, with less emphasis on race, national origin, and gender identity claims, and more limited enforcement and litigation more generally on behalf of the agency. So thank you all so very much for your participation. We really appreciate it. If you have questions, don't hesitate to reach out to Peter or I, and we are happy to get back to you. Have a great day.
Thank you.